Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss section 140 to section 145 of the Bhartiya Sakshya Adhiniyam 2023, that is witness examination.
Now, this section is absolutely fundamental to how a trial runs because it's all about the order in which witnesses are examined. If you're preparing for your judiciary and APO exams, you really need to get this right. So let's jump in. So here's our game plan for this explainer. First, we'll get a solid understanding of what Section 144 is all about. Then we'll break down the rule into its core parts. After that, we'll look at how it actually works in a courtroom, compare it to the old law, and finally, I'll give you those crucial takeaways for your exams. All right, let's start with the basics. Think of Section 144 as the foundation, the very bedrock of trial procedure when it comes to witnesses. So you'll find Section 144 in Chapter 10 of the Bhartiya Sakshya Adhiniyam. This whole chapter is dedicated to the examination of witnesses, which, as you know, is a massive part of any trial. Okay, let's look at the actual text here. It sounds a bit formal, right? But what it really means, in simple terms, is that the sequence of witnesses is supposed to follow the existing procedural law. But, and this is the important part, if the law doesn't specify an order for a particular situation, then the judge gets to decide. It's all up to the court's discretion. So to really get a handle on this, let's deconstruct the rule and look at its core principles. What's it really made of? You can think of this section as standing on three main pillars. The first is procedural law. We're talking about your CPC and CRIPC, the main rule books. The second is the practice of courts, which is just the established way things have been done over the years. And the third, which is incredibly powerful, is the discretion of the court. This is the judge's power to step in and make a call when the law is silent. So if you're going to remember just one thing from today, let it be this. This is the absolute core principle. Procedure governs order, and where silent, the court has discretion. Nail this down, and you've understood the essence of Section 144. Okay, that's the theory, but how does this all translate into what happens in a real live courtroom? Let's take a look. There's a really clear hierarchy of decision-making here. It's a logical flow. Step 1. The court always starts by looking at the procedural laws, like CRPC or CPC. That's the first stop. Step 2. But what if the law is silent? What if there's no specific rule for this exact situation? Well, that leads to step 3. The court's discretion kicks in, and the judge gets the final say on the sequence. Let's use a very common practical example. In almost any criminal trial, what's the standard practice? The prosecution presents its witnesses first. Once they're done, the defense gets its turn. That's the established procedure. Now, this brings up a really interesting question. Is that order completely rigid, or can the court actually decide to change it up? And the answer is a definite yes. If the court feels it's in the interest of justice, or there's some special reason, it absolutely has the power to allow, say, a defense witness to be examined before the prosecution has finished. This flexibility is what ensures a trial remains fair and efficient, which is the whole point. Now, for all of you who have studied the old laws, let's quickly see how this new provision stacks up against the old one. This is a really straightforward change. The same rule used to be Section 135 of the Indian Evidence Act of 1872. Now, under the BSA 2023, it's just been renumbered to Section 144. The substance, the core principle, it's exactly the same. Only the section number has changed. Okay, let's boil all of this down to what really matters for you. What are the key points you absolutely need to know for your judiciary and APO exams? For your prelims, be prepared for direct questions. They'll likely ask about the section number, 144, or its core principle, which is the court's discretion. For the mains, you might see a shortened note question or even a problem-based question where you have to apply this rule. And please remember, this is a procedural section, not a punitive one, so you don't need to worry about memorizing any punishments here. All right, let's do a final, super fast revision. 3 things to lock in. 1, the section is 144 of the BSA. 2, the core concept is simple. The order is decided by procedural law, and if there's no law, the court decides. And 3, its importance is high because it's key to understanding how a trial actually works. And that's a wrap on Section 144. I really hope this breakdown made it crystal clear for you. For more legal explainers focused on your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Hello everyone, and a very warm welcome to Ganga Education. Today, we're going to tackle a really foundational section, Section 141 of the Bhartiya Sakshya Adhiniyam 2023. Now, this section deals with the immense power of a judge to decide whether a piece of evidence is even allowed in court. From an exam perspective for both judiciary and APO, this is an absolutely crucial topic, so let's dive right in and understand it thoroughly.
So here's how we're going to break it all down today. We'll start with a quick introduction to this section. Then we'll explain its core principles. After that, we'll look at some practical examples to see it in action. We'll also cover some landmark case laws, and finally, we'll wrap up with an exam-focused revision. This way, you'll have a complete and clear understanding of the topic. All right, let's start with the introduction. Section 141 gives the judge a very, very powerful role. Think of the judge as the gatekeeper of evidence. What this means is nothing gets into the trial record without the judge's permission. The judge has the final say on what evidence is heard and what is kept out.
Now, this one line you see on your screen, it perfectly captures the entire essence of this section. The number one rule for any evidence to be allowed in court is that it must be relevant. And who's the guardian of this rule? The judge. If a piece of evidence isn't directly connected to the facts of the case, it simply won't be admitted. So let's look at the language of the BEAR Act itself. Subsection 1 makes it very clear. When a lawyer wants to present a piece of evidence, the judge can ask them, how would this fact be relevant if you manage to prove it? And only if the judge is satisfied with the answer will the evidence be admitted. Otherwise, it's rejected. In simple terms, you prove its relevance, your evidence gets in.
So what's the whole point of this section? Why is it so necessary? Well, first, it keeps irrelevant evidence out of the courtroom, which saves a lot of time and prevents confusion. Second, it makes sure that all proof is presented in a logical order. Third, this obviously helps in keeping the trial efficient. And finally, all of this together ensures a fair trial for everyone involved.
So that was a bird's eye view of this section. Now let's dive deeper and break down its core principles, so every essential component becomes crystal clear to you. You can see 4 key terms in this table. The first one is judge's power. This is the supreme authority of the judge to decide what's relevant and what's not. Second, burden on party. This means it's the duty of the lawyer presenting the evidence to convince the court how it's relevant. Third is conditional relevance. This is interesting. It means some evidence can only be admitted after another related fact is proven first. And fourth, judicial discretion. The judge has the power to decide the order in which facts need to be proven. And this flowchart shows you exactly how it plays out in court. It's a very simple flow. Step 1, a party proposes to submit evidence. Step 2, the judge asks that crucial question, how is this relevant? Step 3, if the party can establish its relevance, the evidence is admitted. Step 4, if they can't, it's rejected. It's a clear 4-step logical process. You know, this whole principle can be understood through a famous legal maxim, res inter alias acta, alteri natri non debet. It sounds complex, but the meaning is quite simple. A thing done between 2 people should not harm a third person. In a court setting, this means the evidence must be relevant only to the parties involved in that specific case. An act of some unrelated third party can't be used as evidence here.
All right, we've gone through the theory and principles. Now comes the most important part, seeing how this works in practice. Let's look at some examples that will make it much easier to understand how Section 141 operates in a real courtroom and give you much-needed clarity for your exams.
These are 2 classic examples of conditional relevance, and they explain the concept beautifully. First up, a dying declaration. If you want to use the statement of a dying person as evidence, the first condition you must meet is to prove to the court that the person is in fact no longer alive. Only then will their statement be considered relevant. Similarly, if you want to submit a photocopy of a document, which is secondary evidence, you must first prove that the original document has been lost or destroyed.
Let's take another example from criminal law, say a theft case. Imagine Party A claims that a mobile phone found with Party B was stolen from them. Now, before A can even begin to prove that B stole the phone, A must first prove to the court that the mobile phone is their property. You prove ownership first, then you can allege theft. The judge enforces this logical sequence.
Now that we've covered theory and examples, let's see how our apex court, the Supreme Court of India, has interpreted this provision. Remember, case laws are extremely important for your exams because they show how the law is applied in real-life situations.
R.M. Malkani versus State of Maharashtra is a true landmark judgment. This case established a very critical principle. The court held that the admissibility of evidence hinges on its relevancy, not on the method used to obtain it. So the key takeaway is, if the evidence is relevant and helps uncover the truth, it might be admitted, even if the method of collecting it was technically illegal.
This very principle was carried forward in the case of Puran Mal versus the Director of Inspection. Here, the question was direct. Can evidence obtained through an illegal search and seizure be admitted in court? The court's answer was a clear yes. If the evidence is relevant to the case, the court will consider it, regardless of any procedural flaws in the search. The court's focus is on the main case, not on conducting a separate trial about how the evidence was collected.
Okay, let's move to our final segment, which is all about your exams. Here, we're going to summarize all the crucial points that you absolutely need to remember.
With the new criminal laws, you might be wondering what's changed. Well, we used to have the Indian Evidence Act of 1872, and now we have the Bhartiya Sakshya Adhiniyam 2023. But listen carefully. The core principle of Section 141, the judge's control over admissibility, is exactly the same. The fundamental idea hasn't changed. The new act simply modernizes the procedures, especially for things like electronic evidence.
Now let's get down to some solid exam tips. In your prelims, you can expect a direct section-based question like, which section gives the judge the power to decide the admissibility of evidence? The answer is Section 141. For your mains exam, you might get a problem-based question where you're given a scenario and asked to decide if the evidence is admissible with reasons. Or you could be asked to write a short note on judicial discretion in admissibility of evidence.
So what is the single most important takeaway from this entire discussion? If you remember just one thing, let it be this. The judge is the ultimate gatekeeper of evidence. All control is in the judge's hands. This one phrase will help you remember the core of this section forever.
Let's do one final quick revision. Which section are we talking about? Section 141 of the BSA 2023. What's the core concept? The judge decides admissibility based on relevancy. What's the key principle? Relevancy is the test for admissibility. And its importance for exams? High for both prelims and mains.
And that's all for our explainer on Section 141. I truly hope this session has made all the concepts crystal clear for you. For more detailed, exam-focused content for your judiciary, APO, and other law exams, stay connected with us here at Ganga Education.
Welcome, everyone, to Ganga Education. Today, we're going to dive into 3 of the most foundational sections. That's sections 142, 143, and 144. These sections literally set up the entire framework for witness examination. And for your judiciary and APO exams, this topic is absolutely crucial. So, have you ever really thought about it? When a witness is called into court, how is the whole process of questioning actually controlled? How does the law ensure everything is fair and doesn't just descend into chaos? Well, the entire rulebook for that is found right here within these specific sections of the Indian Evidence Act. Now, it's really important to understand that you can't look at these 3 sections in isolation. You have to see them as a package deal. Why? Because together they create a complete blueprint, a roadmap that tells us exactly who can question a witness, when they can do it, and what kind of questions they're even allowed to ask. Think of this table as our guide for today's discussion. First up, we have Section 142, which defines the different types of examination. Then we move to Section 143, which sets out the order and the scope, the boundaries of those examinations. And finally, we'll look at Section 144, which handles a very special case, the rule for a person who's only there to produce a document. Okay, let's kick things off with Act 1, the 3 stages. This is the bedrock, the foundation of the whole process, and it's all laid out for us in Section 142. This section explains that every witness examination is broken down into 3 very distinct parts. So, what's that sequence? Section 142 makes it crystal clear. First, you have the examination in chief. This is followed by cross-examination. And to wrap things up, you have the re-examination. And listen, this order is absolutely fixed. It's not something that can be changed on a whim. And each of these stages has a very specific job. In the examination in chief, the party that called the witness presents facts to support their case. Then the opposite party gets their turn in cross-examination to really test the truthfulness of those facts and, of course, the witness's credibility. Finally, if any doubts or confusion popped up during cross-examination, the original party gets a chance to clear things up in re-examination. It's a very logical and fair system. Now we come to Act 2, the order and scope. This is where Section 143 steps in, and it essentially lays down the rules of engagement for these three stages. It doesn't just confirm the order we talked about, it does something even more important. It defines the scope, the limits of the questions you can ask at each stage. And here's where it gets really crucial. The difference in scope. You see, in the examination in chief, you're restricted. You can only ask about relevant facts. But cross-examination is a whole different ballgame. Its scope is much, much wider. The very purpose is to shake the testimony, to probe deeper, so you can ask about things that weren't even brought up in the chief examination, all in the pursuit of bringing out the whole truth. Let's walk through a practical example to really see this in action. Imagine in the chief examination, a witness states, "I saw the accused at night." Seems straightforward. But now, in cross-examination, the opposing lawyer can start digging. They might ask about the lighting, the distance, the witness's eyesight, or even if there's any prior enmity with the accused. Then, in re-examination, the first lawyer can step in to clarify, asking something like, was there a streetlight nearby that was on? This helps to paint a complete and clearer picture. Finally, let's move on to Act 3, the document rule. Section 144 gives us a very specific and incredibly important exception to the rules. This is for a person who has been summoned to court for one reason and one reason only, to produce a document. This is a critical legal distinction you need to remember. Simply producing a document does not make you a witness. If someone is summoned to court just to hand over a file or a document, they are not considered a full-fleshed witness, and therefore, they cannot be cross-examined. So, when does cross-examination become possible? Well, only when that person is formally called to testify as a witness. For example, if a bank officer simply submits a bank statement in court, they can't be cross-examined. But if that same officer is then called to the witness box to testify about the entries in that statement, now they've become a witness, and that means they can absolutely be cross-examined. You know, this entire structured procedure isn't just a set of random rules. It's all built upon a fundamental principle of law, audi alteram partem, which literally means hear the other side. This is the very heart of natural justice. Examination in chief gives one side a chance to speak, and cross-examination gives the other side their chance. It's this beautiful balance that upholds justice. And this isn't just theory. In the landmark judgment of State of Kerala versus Rashid, the Supreme Court itself called cross-examination a vital tool for discovering the truth. The court made it clear that without cross-examination, the principle of audi alteram partem would just be empty words in a textbook. This case really gives judicial teeth to the importance of this process. Okay, let's shift our focus to something extremely important for your upcoming exams. This comparison. With the new criminal laws now in effect, it's absolutely mandatory for you to know the new corresponding sections from the old act. I can almost guarantee you'll see a direct question on this in the judiciary prelims. So please, make sure you note down the new section numbers from the Bhartiya Sakshya Adhiniyam that correspond to these old sections of the Indian Evidence Act. Don't skip this part. All right, let's do one last quick revision of the entire topic, just to make sure all these concepts are perfectly solidified in your mind. Here's your exam strategy. For both prelims and mains, having a combined understanding of these three sections is key. In prelims, expect direct questions on the section numbers and their core concepts. In mains, be prepared for a problem-based question or a short note that ties all three of these sections together. So, for a super fast revision, just lock in these three things. The section numbers, 142, 143, and 144. Their core concept, they establish the entire structure of witness examination. And their exam importance, very, very high. So what's the ultimate takeaway from all this? These sections are not just some dry procedural rules. They are the very backbone of a fair trial. Without them, our adversarial system of justice would have a much more difficult time effectively discovering the truth. For more in-depth legal content focused on judiciary, APO, and other law exams, please stay connected with us here at Ganga Education. Namaskar and a very warm welcome to Ganga Education. चलिए आज की डिस्कशन एक बहुत ही इंटरेस्टिंग सवाल से शुरू करते हैं। जस्ट इमेजिन कोर्ट में एक विटनेस आके कहता है कि किसी इंसान का कैरेक्टर या तो बहुत अच्छा है या बहुत बुरा। सो द क्वेश्चन इज, क्या कोर्ट को उसकी बात बस ऐसे ही ब्लाइंडली एक्सेप्ट कर लेनी चाहिए? Is testimony about character the final truth? वेल, इसी सवाल का जवाब हमें मिलता है कि सेक्शन 145 में। एंड लेट मी टेल यू, जुडिशरी और एपीओ एग्जाम्स के पॉइंट ऑफ व्यू से ये सेक्शन एब्सोल्युटली क्रूशियल है। तो आइए इसे आराम से डिटेल में समझते हैं। तो ये सेक्शन 145 आखिर है क्या? बेसिकली ये उन विटनेसेस से डील करता है जो किसी पर्सन के कैरेक्टर पर टेस्टिमनी देते हैं, और ये रूल सिविल और क्रिमिनल दोनों ही केसेस में अप्लाई होता है। सो व्हाट्स द कोर प्रिंसिपल? लेट्स फाइंड आउट। द बेयर एक्ट की लाइन बिल्कुल सिंपल और स्ट्रेट फॉरवर्ड है। ये कहती है कि कैरेक्टर के विटनेसेस को क्रॉस एग्जामिनेशन और री एग्जामिन किया जा सकता है। नाउ इसका मतलब क्या हुआ? इसका गहरा मतलब ये है कि कैरेक्टर एविडेंस को कोई स्पेशल प्रोटेक्शन नहीं दी गई है, उसे भी बाकी सबूतों की तरह कानून की कसौटी पर परखना ही पड़ेगा। ओके, टू रियली गेट अ ग्रिप ऑन दिस, लेट्स ब्रेक डाउन द कोर इंग्रेडिएंट्स ऑफ दिस सेक्शन। इससे पूरा कॉन्सेप्ट एकदम क्रिस्टल क्लियर हो जाएगा। सो इस सेक्शन के 3 मुख्य एलिमेंट हैं। फर्स्ट, टाइप ऑफ विटनेस। यहाँ हम उस गवाह की बात कर रहे हैं जो किसी व्यक्ति के मॉरल कैरेक्टर, उसकी रेपुटेशन या उसके बिहेवियर पर गवाही दे रहा है। सेकंड, एग्जामिनेशन अलाउड। यहाँ एडवर्स पार्टी उस विटनेस को क्रॉस एग्जामिन कर सकती है तो चैलेंज द क्रेडिबिलिटी, और जिस पार्टी ने विटनेस बुलाया है वो री एग्जामिनेशन करके क्रॉस एग्जामिनेशन से उठे पॉइंट्स को क्लैरिफाई कर सकती है। एंड फाइनली थर्ड, स्कोप। ये बहुत इंपॉर्टेंट है कि सारे सवाल जवाब सिर्फ और सिर्फ कैरेक्टर से जुड़े फैक्ट्स तक ही लिमिटेड हो। ये स्लाइड आपको दिखाती है कि कोर्ट में ये प्रोसेस चलता कैसे है। सबसे पहले विटनेस कैरेक्टर पर एविडेंस देता है, फिर एडवर्स पार्टी उस टेस्टिमनी की सच्चाई को परखने के लिए क्रॉस एग्जामिन करती है। इसके बाद अगर कोई कंफ्यूजन क्रिएट हुई है तो ओरिजिनल पार्टी री एग्जामिनेशन से उसे क्लियर करती है, और आखिर में कोर्ट सारे फैक्ट्स को कंसिडर करके डिसाइड करती है कि कैरेक्टर एविडेंस कितना विश्वसनीय है। देखिए, थ्योरी को समझने का सबसे अच्छा तरीका है उसे प्रैक्टिकल एप्लीकेशन में देखना। तो चलिए एक कोर्टरूम एग्जाम्पल से समझते हैं कि ये सेक्शन रियलिटी में काम कैसे करता है। मान लीजिए एक थेफ्ट का केस है। डिफेंस का विटनेस आकर कहता है कि अक्यूज तो एक कानून का पालन करने वाला शरीफ इंसान है। अब प्रोसिक्यूशन का काम है इस दावे को टेस्ट करना। क्रॉस एग्जामिनेशन में वो पूछ सकते हैं, क्या आपको पता है कि इसी शरीफ इंसान को 5 साल पहले चोरी के लिए सजा हो चुकी है? ये सवाल सीधा विटनेस की क्रेडिबिलिटी पर अटैक है। इसके रिस्पॉन्स में डिफेंस री एग्जामिनेशन में उस पुराने केस का कॉन्टेक्स्ट क्लियर कर सकता है। किसी भी लीगल प्रोविजन को पूरी तरह से ग्रास्प करने के लिए उससे जुड़े केस लॉज और लीगल मैक्सिम्स को जानना बहुत ज़रूरी है। यही हमें उस सेक्शन की रियल इंटरप्रिटेशन और स्पिरिट तक ले जाते हैं। और इस कॉन्टेक्स्ट में एक बेहद इंपॉर्टेंट लैंडमार्क केस है स्टेट ऑफ महाराष्ट्र वर्सेस बलीराम। इस केस में सुप्रीम कोर्ट ने बिल्कुल साफ कर दिया था कि एक कैरेक्टर विटनेस की टेस्टिमनी पूरी तरह से क्रॉस एग्जामिनेशन के अंडर आती है। कोर्ट ने कहा कि ऐसा करना उस गवाही की क्रेडिबिलिटी और रिलायबिलिटी को टेस्ट करने के लिए ज़रूरी है। सीधे शब्दों में, कैरेक्टर विटनेस को कानून में कोई स्पेशल इम्यूनिटी हासिल नहीं है। ये पूरा सेक्शन नेचुरल जस्टिस के एक फंडामेंटल प्रिंसिपल पर बेस्ड है, ओडी अल्ट्रम पार्टम। इसका मतलब है दूसरे पक्ष को भी सुनो। सेक्शन 145 इसी प्रिंसिपल को इन्फोर्स करता है। ये इंश्योर करता है कि अगर एक पार्टी कैरेक्टर एविडेंस लाए तो दूसरी पार्टी को उसे चैलेंज करने का पूरा मौका मिले। यही तो फेयर जस्टिस है। तो अब सवाल ये उठता है कि आखिर कोर्ट में कैरेक्टर एविडेंस की वैल्यू क्या है, उसकी एविडेंशियरी वैल्यू कितनी है, और इस सेक्शन का असली मकसद क्या है? व्हाई डज इट मैटर सो मच? देखिए, ये समझना ज़रूरी है कि कैरेक्टर एविडेंस कोर्ट में एडमिसिबल है, यानी उसे कंसिडर किया जाता है, लेकिन ये कंक्लूसिव प्रूफ नहीं है। इसकी वैल्यू विटनेस की क्रेडिबिलिटी पर डिपेंड करती है, और अगर उस टेस्टिमनी को सपोर्ट करने के लिए दूसरे एविडेंस भी हो, जिसे हम कोरॉबोरेशन कहते हैं, तब इसकी इंपॉर्टेंस और बढ़ जाती है। इस सेक्शन का मेन ऑब्जेक्ट है फेयरनेस को एंश्योर करना। ये इस चीज़ को रोकता है कि कोई पार्टी सिर्फ अच्छे कैरेक्टर का हवाला देकर केस जीत जाए। ये दोनों पार्टीज के बीच एक बैलेंस बनाता है और एस्टैब्लिश करता है कि हर क्लेम को एविडेंस की कसौटी पर परखा जाना ज़रूरी है। ऑल राइट, अब आते हैं इस एक्सप्लेनर के सबसे इम्पॉर्टेंट पार्ट पर, खास करके आपकी जुडिशरी और एपीओ एग्जाम्स की प्रिपरेशन के लिए। लेट्स सी कि इस सेक्शन से एग्जाम्स में कैसे सवाल आ सकते हैं। प्रीलिम्स एग्जाम में सेक्शन 145 से एक डायरेक्ट क्वेश्चन आ सकता है। फॉर एग्जाम्पल, विटनेसेस टू कैरेक्टर कैन बी क्रॉस एग्जामिन्ड अंडर विच सेक्शन। जबकि मेंस में आपसे एक प्रॉब्लम बेस्ड क्वेश्चन या शॉर्ट नोट पूछा जा सकता है, जहां आपको एक सिचुएशन देकर उसे सेक्शन 145 के बेसिस पर एनालाइज करना होगा। चलिए एक क्विक रिवीजन करते हैं। एग्जाम के लिए ये 3 चीजें हमेशा याद रखिए। पहला, सेक्शन नंबर 145। दूसरा, इसका कोर कंसेप्ट कैरेक्टर विटनेसेस कैन बी क्रॉस एग्जामिन्ड एंड री एग्जामिन्ड। और तीसरा, इसका प्रिंसिपल कैरेक्टर एविडेंस एडमिसिबल है, लेकिन उसकी रिलायबिलिटी को स्क्रूटनाइज करना अनिवार्य है। और हाँ, एग्जाम के लिए इसकी इम्पोर्टेंस हाई है। जुडिशरी, APO और दूसरे लॉ एग्जाम्स के लिए ऐसी ही इम्पोर्टेंट लीगल कंटेंट के लिए गंगा एजुकेशन के साथ जुड़े रहें।
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.